Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call, which we hold every 2 weeks, every other Thursday, usually. I'll be answering the questions that have been posted, first the ones that I have marked as frequently asked questions, then the routine questions that everybody else has asked, and finally, if time permits, we'll take on new questions. With that said, let me begin with the first frequently asked question. Madhu wants to know what will happen if H-4 EADs are revoked by the USCIS. What will they do to the existing H-4 EADs? Will they impact the currently approved EADs? I've dealt with this issue before, but I'll do it one more time. Government was supposed to have acted to revoke the H-4 EAD program altogether a few months back. My confusion with government's need or action to do that was because of a couple of reasons. I did not think government will be able to easily revoke the H-4 EAD regulations for two reasons. One, when you have a regulatory change, there's got to be some reason for it. You cannot just one fine morning wake up and say, I am going to change an existing regulation. That was my understanding. Second thing that does not make sense is that in this extremely low unemployment time, what is the urgency or the necessity to revoke H-4 EADs for a whole class of highly qualified individuals, the spouses of H-1B holders? So the government has not done it so far. We don't know whether they will do it. Will they revoke the H-4 EADs? But your questions about what happens to the existing H-4 EADs is a valid one. All I can give you is a common sense answer. I think if they do revoke, they will revoke giving a grace period to existing H-4 EADs. My guess would be about 6 months to existing H-4 EADs that have been approved, or whatever the duration remaining on the current H-4 EAD is, whichever is shorter. So maximum of 6 months. I think that's what they would do. That's what makes sense. I have told people that they should renew their H-4 EADs as quickly as they can the moment it is time to file. I think it's 6 months ahead of time. So don't wait up on that. You should continue to keep getting your H-4 EADs extended. I do not know where the regulations will go eventually, but there should be a grace period. And I wouldn't be surprised if they also have, that's also normal, they would have a date from which the regulations would become effective. So let's say they pass the regulations demolishing the H-4 EAD program today. They might make the program effective 3 months or 6 months from the date of the regulations, and they further might give a grace period to people who already have approved H-4 EADs. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay, you do not. Let's go on to the next frequently asked questions. And this is also a question I have dealt with many times before. Can I work on other projects or businesses while I'm on H-1B? So the question asked by Amar Singh was, which of the following activities are okay to do while in the H-1B status? Number 1, purchase real estate and then later rent it out. Nobody really knows the answers to these questions unless they are extreme. So if you, for example, you cannot get an unauthorized job on the side, that we know. But what about these activities that are short-term projects or may not be considered to be employment? There, the laws leave us to make reasonable guesses. And my conservative guess would be, if you purchase real estate to do any activity on it, such as lease it or turn it around and sell it again, I think that comes very close to unauthorized employment. I'm not aware of any clear answer, but I do think that any activity that is passive and doesn't require you to act a lot except writing a check to buy it, buy or invest in it, should be okay. But the moment you become closer to actually doing anything related to that investment, such as leasing, I think you have a problem. We have a case, an interesting case, an EB5 case, in which the gentleman was on H1B and he took some courses on real estate investments. He got some investors together, bought their first apartment building, and eventually, using some of his own investments, etc., filed an EB5 investment-based green card for himself. I was definitely skeptical about the propriety of doing business on the side while you're on H1B. His saving grace was the active partner in the business, who was a minority stockholder, was herself a real estate broker. So he was probably not doing a whole lot of activity. Government seems to have accepted that, and they did not question her status. But under the Trump administration, they will try to find every reason they can to have you fall out of status. So I think purchasing real estate as a passive investment might be okay, but to lease it out yourself may not be okay. Would it be okay to lease it through a managing real estate manager? Maybe okay. Hard to say. Passive investments are okay, active participation is not. Volunteer for a non-profit organization. That's easy. Absolutely okay. As long as you don't get any money or other benefits in return, you can definitely do it. Volunteer for a non-profit organization outside the USA, like translate stuff into English. I don't see any problem with it. Work for a company outside the US. I have seen lawyers advise that if the work that you are doing has no connection with the USA, no business being conducted by the company in US, no bank accounts in US, it might be okay to work for a foreign company on a foreign job while you are yourself in USA. I don't think that's correct, but government seems to have tolerated that according to some of the incidents I have heard from other lawyers. I still have my doubts. So be as passive as you can. What is the downside of unauthorized employment? Interestingly, like many things in immigration law, if you break some law, whether knowingly or unknowingly, you may be okay if you tell the truth, but if you lie about it or try to conceal it, you may have some very serious complications. So the worst case scenario, if you tell the truth, maximum the government can say is, oh, you're out of status, go outside USA, get another H1B visa stamp. No end of the world. Okay. But again, these are some of these activities that I've commented on are my best guesses, and that's all I can give you. Star 5 if you have a follow-up question on this. Star 5 if you have a follow-up question. Okay. Let's go on to the next frequently asked question. So what happens if I have multiple H1B approvals? Well, the rule of the thumb is if you're already on H1B, or you are going from, let's say, F1 to H1B, and you have multiple approvals, each one with a change of status or extension I-94 attached, you can actually take any one of them. Approval of one does not revoke the previous one. So let's say I'm working on an H1B with company A, company B, C, D, file for my H1B, all of them get approved, all of them have an I-94 attached. I can choose to work for any of these companies. Now, if you have signed contracts with these companies that you will join them, you may have legal exposure under those contracts, but under immigration law, just because somebody else's H1B is also approved does not revoke or minimize an existing H1B. So what if you, after having gotten approvals from B, C, D, you still want to continue working with the old employer A? That's perfectly okay too. So let's look at the question. I have an I-140 approved, current employer. Another employer wants to transfer. Once H1 transfer is approved, can I still continue working with my current employer? Yes, you can. Will that create any problem in my future extensions? No, it won't. Can I keep multiple H1B transfer approvals? That's a difficult question to answer because there is an inconsistency in obligations. It's okay for you to have multiple approvals, but it's not okay for the employers, generally speaking, to keep an approval valid indefinitely. They should either revoke the H1B, otherwise they are liable for salary. So it's a violation of law or policy at least for an employer not to inform the USCIS that you're not working with them. Star 5 if you have a follow-up question on this. Press star 5 if you have a follow-up question. Okay, let's see if there's any other frequently asked question. I don't think there is. All right, let's go back to the regular questions. First one is, this is number 3, question number 3 from Vineet. Is it safe to change to a new employer based upon an EAD card received 2 months earlier? I-485 appointment completed with the USCIS. Expect to receive my green card by the end of October. I've had a very odd case. We were retained to file a motion to reopen for a gentleman who was working for an employer X while his I-140 was filed. But before the I-140 was, I'm trying to remember. Okay, the I-140 was approved, but before the I-140 and 485 were pending for 180 days, he filed the 485 also. Not India born, some other country born. So before 180 days, he moved on to another employer. Okay, so I-140 is approved, but before 485 was pending 180 days, he moved. You know that after 180 days, you can move anyway to a same or similar job. Government has denied his I-485. I think it's illegal, and my instructions are, if necessary, to take it to the Court of Appeals, take it all the way as far as we need to win this case. And I think on the question of law, the government has very, very weak stand because they are taking the stand that not only must the I-140, 485 remain, let me rephrase that, not only must the 485 remain pending 180 days, you must have the intention to remain with the same employer. And I said, no, that's not the policy, nor is that the law. So it's okay for you to have a change of heart before 180 days are over. Why am I saying all this? Because the government is trying to bring in all these new ideas to try to deny your cases. You have a great job offer. You are very close to the end of the green card. You have two options. Wait until the green card is approved, wait another reasonable period of time, then move. Or 2, file a supplement J. Can that delay your 485? It can. But would that save your naturalization? Absolutely. I think it's a very good idea. So if I were you, I would file a supplement J to indicate to the government that you intend to change over. As long as your 485 has been pending 180 days. Oh, it has crossed already. So good. Yeah, I would do a supplement J for sure. I think that's pretty safe as long as the jobs are same or similar. Somebody has a question. Actually, I haven't finished my answer. But this is from New York. Okay. Let's see. New York, go ahead if you have a question. Yes, New York, go ahead.
Yeah, this is really clear. Thank you. So I have got. Thank you for answering my question. I appreciate that. My 140 is approved about 1.5 years back, and 485 is also approved and passed. Pending approval since last more than 180 days.
Right.
And after that, the appointment with the officer completed. So I think this is a safe period to go with 485J with a new employer.
Yes.
And then
yes.
take up the new opportunity.
Yes,
right?
That's exactly what I would do. Yes, sir.
Excellent. But the role description would be slightly changing. It's a next level role. Is that
See,
safe again
yeah,
from the naturalization perspective?
remember the language used in AC 21 laws is that the next job should be same or similar. When we use the word similar, it automatically means it's not the same. Okay. And promotions within the same category of jobs are perfectly okay. For example, if you go from software developer to systems manager, that's okay. You go from database administrator to database administration lead, that's okay. You go from software developer to project manager, that's okay.
Excellent. That's exactly the same category I'm falling in.
Right.
Thank you very much. This gives a peace of mind.
You're welcome.
I'll go with 485J and proceed with that. Thank you very much.
Absolutely. Good luck, sir.
Welcome.
Okay, so we go on to the next question is from Shweta. I have a question about getting a new H1B after doing a master's program. So she wants to know, if I do a master's degree, do I get another 6 years of H1B? And the answer is no. No. You get a total of 6 years of H1B, no matter what your degrees are. The only way to reset an H1B is to go outside USA for 1 year. But then you also become subject to the quota again. Of course, filing a green card is a great way to earn the right to keep extending your H1, but resetting the H1 does not become a possibility just because you changed degrees and went from bachelor's to master's degree. Shweta, if you are here and if you have a question, press *5. Anyone has a follow-up question on this topic, press *5, please. *5 on your phones. Question number 6 from Danny. How long between NVC letter and interview date at Mumbai consulate? I'm going to make a guess. I do not know for sure. I would say 6 to 9 months is normal. Okay, 6 to 9 months. But these periods can change. I'm making a guess based upon some of the relatively new cases in our office. *5 if you have a follow-up question. *5. Ruchak has, this is question number 7, graduated with a master's degree in historic preservation, which is a special kind of architecture and construction degree. So he's trying to figure out which job is better for getting an H1B approval. Both jobs are related to my master's degree. One is with a relatively large firm having 7 to 10 people, all non-H1B. The other one is an independent practitioner who's been working for 40 years but nobody working with them. Okay, first thing I would want to make sure is whichever employer you go with, they should be able to stand with you in case there is an RFE which is common, it's going to come through, and they might have to provide documentation and or pay expenses related to fighting the RFE. Okay, this is the most important thing. Who will stand with you, whether the single guy or the 7, 8, 10 people company? Second thing, which will be very important, let's say your job is preservation engineer or preservation architect. If either one of these two companies has advertised for these jobs requiring a degree, a master's degree in historic preservation, you should go with them, because chances of getting approval through them is better because they have already articulated that they will not accept a degree less than a degree in historic preservation for this job. So 2 items. One is who's going to assist you all the way to the end, and 2, who has a track record of hiring degreed people, degree in specifically either historic preservation or architecture for this kind of job in their company. *5 if you have a follow-up question, Press *5, Ruchak. Okay. Aksal 123, parents are green card holders since 2009, dad since 2016, sponsored by US citizen uncle. They are now both above 65. I and my wife are on H1B and my daughter is a US citizen by birth. The public charge rule. I have not really had the time to review the public charge rule. I have a very vague idea because most of our clients are not affected by this, so I haven't had to deal with it. If I get time over the weekend, I'll try to write something up for you guys, because I'm now beginning to get questions even from the H1B holders and the professionals. So I think I'll take a look at the regulations and see how they affect. But here is my understanding. These regulations do not apply to people who are already on green cards. There might be an indirect effect, but no direct effect. And secondly, people going for citizenships. It's the people who are converting to green card or entering the United States on a non-immigrant visa or on a visa that resets their green card status. I'll explain to you what that means. When you are a green card holder and you leave USA for less than 6 months, government cannot agitate new issues. But if you are coming back after 6 months or more, they can treat your entry as admission, which literally means they can question a lot many more things than they would normally be able to. So therefore, it is my opinion or my understanding, I haven't had the chance to look at the details. I'll try to create either an audio file or I will create some kind of a blog entry. And I usually post to our Facebook page, LinkedIn page, immigration.com, as well as Twitter. So I'll have that posted. By the way, all our social media is on the top right-hand corner on immigration.com. You can subscribe to and follow there. So let me double check this, Aksal. Don't take my word for it because I'm still not fully versed in the regulations. Haven't had the time. It's 200 plus pages of information. I'll take a look at it hopefully this weekend. Now, question number 10. Oh, there's a follow-up. This follow-up is from New Jersey. New Jersey, go ahead, please. We can hear you. New Jersey.
Mr. Khanna, this is Akhil. No, thank you so much. I think you're on the right understanding as well. Preliminary though, but understanding that's been more or less my understanding reading the different documentations. But the related question to this that I have is, what about renewals? So my mother is up. She's been on the green card for almost 10 years now. She's up for renewal.
Renewals.
Now, will it affect?
No, renewals are just an administrative affair. So far, government has not applied any new set of laws to renewals. They cannot. I don't think the regulations allow them to apply new sets of laws to renewals. I don't believe that is the truth. But I'll double check it. Law can always surprise you. My legal common sense tells me that should not be a problem. But I do want to double check it. I have your questions. If you guys have any questions about...
Because they're currently availing Medicaid.
Okay.
So with the new, not long-term but short-term, meaning just regular Medicaid.
Okay, let me do this. Let me get a book chapter started on immigration.com. We have a facility called books. So I can start a book with different chapters. First chapter can contain the regulations. The second chapter can will be our commentary. And each data point can have your questions and my answers on it. I haven't been able to work much on our website for the last few months. We have been so swamped with Trump administration's nonsense that I've had no time to really do any community work. But now things are getting a little bit more under control. So I hope to, fingers crossed, this weekend start a chapter on, or start a book on the new regulations on a public charge issue. Stand by. I'll post it. Follow me on Twitter, LinkedIn, wherever you feel like, and I'll post it on social media when I start the chapter.
Sure. Thank you, sir.
And then you can refine your questions and post them there, and I'll do my best to answer them.
Sure. Thank you.
You're welcome. Good luck, sir.
Thank you.
Okay. So the next question is number 10. And this was a follow-up on the August 22nd conference call. Please review the policy and advise whether I'm able to refile the I-140. So in your case, what happened was you had an earlier I-140 which was rejected for inappropriate fees. Your employer applied again with the new fee, but the 180-day period was over. Okay. So they have started the green card again. Now, sir, what I would want you to do is, I don't have time to research this issue, although it's only going to take me 5 minutes, but even finding 5 minutes in the day can be difficult sometimes because we are so busy with our existing cases. What I want you to do is, there is actually a memorandum on this, and I think it was also put as a part of the January 17th, 2017 regulations about how to deal with the 180-day period. I'll give you the general idea of what the law is. So once your perm is approved, you have to file your I-140 within 180 days. But once you have properly filed it and it gets denied or you withdraw it, you can refile it anytime. You're not confined to the 180 days period. Only the first filing has to be within 180 days of the perm approval. Now the question is, would the policy let me extend this principle of relaxation of the 180-day confinement in cases where there was a denial because of inappropriate fee? I don't know the answer to that question. And sir, I would advise you to have your lawyers look at it very carefully, and I don't know where you are located, but even litigate this issue, because this is an issue which is really, if the regulations allow for it, you may not have a case, but if you have any chance of arguing this before a judge and you can save a few years' time, I would advise you to very seriously consider litigating it. Okay. We've been out of litigation for a few years, but now even we have to get back into litigation because I was a litigating lawyer for many, many years, decades of my life. But last many years, we've not had any reason to sue the government. I just filed, after many years, our first lawsuit against the government on a naturalization delay case. So I think filing lawsuits now will become a part of a normal immigration practice. I don't think we have a choice. So sue them. Okay. *5 if you have a follow-up question. *5. Okay. Let's go on to question number 11 and 12 are related. So here, Mr. Kumar, congratulations on your nuptials. You're getting married. How can I bring her here the quickest way possible? First of all, never, ever bring your spouse or intended spouse on a tourist visa and then try to convert her to a green card. This is often treated as fraud by the government, because to use a tourist visa to enter the United States with an intention to get married and convert to green card is a fraud. So please be careful with that issue. Tourist visa is never a good option. People have done that. Government has not questioned that in the past, but I think more and more they will question. You've got your US citizenship. Should I do a K1 visa? Okay, well, let me explain to you how K1, K3 and green card work. None of them is a quick option, but many times what happens is Indian parents, or in fact many of the, not only Indian, when I say Indian I mean Desi, which is Indian, Pakistan, Bangladesh, Afghanistan, our people from these areas may be very conservative. They may not want to send their daughter or maybe even their son to USA on a fiancé visa. A fiancé visa is only available if you are not yet married. that may be the quickest option. It's still not very quick. It can take several months. So if that is not the case, that they are not going to let let me rephrase that. If that is the case, that the parents of your spouse are not going to let him or her come to USA without a marriage, then what you should do is get married. And remember, under US laws, if a marriage is valid and legal, in brackets, unless against public policy in USA, for example, getting married to a 12-year-old girl, unless against public policy, USCIS and the US government will accept all marriages as legal if they are legal in the country in which they were performed. So in India, for example, if you're a Hindu, you go around the fire 7 times with all the proper hymns, etc., and you're considered to be legally married, that's accepted in USA. You don't have to do anything more than that. So remember, don't think that just because you got married in a religious manner, you are still unmarried according to US laws. That's a very common mistake. So if you want to get married, go ahead and do that. Then apply for K3 and I-130 together. So green card and K3, not K1. K1 is for when you are unmarried, fiancé visa. The way this works is, and I'm speaking from memory, there are other people in our firm who take care of all the family-based cases, and I only provide overall strategy and deal with the more difficult issues. Routine issues I may not recall to 100% accuracy. I have to review them. But from what I recall, we file K3 right after we get the receipt of the I-130. And once we file the K3, whichever comes first, green card or K3, will be given to her at the consulate. The only time they will not issue a K3 is if they have received official notification at the consulate of approval of the green card. Then they'll say, you just have to wait a few more weeks to get the green card. We are not going to give you a K3. So it's always a good idea to file a K3 and a green card together or in quick succession. Now remember, certain kinds of visas, H1s, L1s, O1s, E visas not available to Indians, E3 visa Australians, these are immune from marriages. So if your wife or your husband can qualify for any one of these visas, you can be married and have the green card going on while they move to USA using their H1B, L1, O1, or any of those visas I mentioned. Definitely please don't use the tourist visa option. It's such a bad idea. *5, if you have a follow-up question, press *5. Okay. Axel, we already talked about, there is a question from Virginia. So this is from my neck of the woods. Virginia, let's see. Virginia, go ahead, please. We can hear you. Virginia.
Okay. I have one question. If I marry in India and stay there for some time, do I need to have a job in US?
Okay, that's a very good question and very interesting question. I'm assuming that you are either a US citizen or a green card holder, right?
I'm asking for my brother. He is a US citizen.
Okay. So green card holders have other complications, but for a US citizen, it is not required that they have a job if they have enough savings, because they have to give an affidavit of support for their spouse. Are you talking about if he wants to get married? Is that what you're talking about?
Yes, I'm asking on behalf of my brother. If my brother gets married in India,
right. So he can stay. He can stay with his wife as long as he has enough money to support her at the time of the filing of the 480 of the affidavit of support. Now, before she goes for the interview, he should either have moved back or he should be able to show that he's in the process of moving back. So he can stay for 8, 10, 12 months, But towards the end of the process, he should either move back or be able to show that he's actively in the process of moving back. For example, looking for jobs, rented an apartment, things like that. Okay?
Okay. And if I get married in India, then the paperwork, I know that paperwork that
pretty much the same.
Takes a lot of time, more than 14 months.
No, it's the same amount of time as it would from here. I don't see what the difference is. Okay.
So what is better according to you?
You don't have a choice. You can't bring visa. You don't have a choice. You cannot bring people in on a tourist visa. If somebody is here on H1B, L1, EAD, O visa, great, get married here or bring them here on those visas. But if not, you have no choice. They have to be married in India. Apply either from here or there. It doesn't really matter. It goes to the same process. Okay.
Okay.
All right.
Thank you.
You're welcome. Good luck. Okay. Aksal, I answered that question. Now, this is a very difficult question to answer, Christian. You want to, this number 14, I have an RFE regarding specialty occupation. I have a bachelor's in electronics, engineering, etc. 15 years of software experience. Well, first of all, programmer is a very bad title. It is a questionable title because government takes the position that programming, coding doesn't require a degree. Okay. Expert opinions, etc. are common. We do that also. But not regular kind of expert opinions. They have to be some very, I can't tell you how to, I'm sorry, this is a difficult question to answer. But if the case gets denied, talk to somebody who's used to these kinds of cases because I don't know why you would even file under software developer. And an evaluation should have been done before you filed the case. Okay. So I'm not sure what's going on here. My wife works on EAD. Can she work post-September if my case will be pending? Well, as long as you are maintaining your H1, she can continue working. Will I get a chance for H1B filing with a different employer? You might have to go outside USA and come back in. But yes, you can apply through different employers. That's not a problem. And they're not approving H4 EADs concurrently with your H1Bs anymore. There might be some time gap. My employer location is in Indiana. I reside in Virginia. I don't know about the filing location, sir. Somebody else takes care of all that. I am the strategy guy. I don't know the bricks and mortar, okay? So, but yeah, this is hard for me to say how it will play out, but government can question this, and they often do. The moment you see a degree in electronics, you should be ready for that question. Okay. *5, if you have a follow-up question on this, I can't give you too much information because there are so many different ways to handle this. *5. Okay. Let's go on to question number 15. So Adi is a manager in an in-house project, managing people. Employer has a development center. I'm going to go work there. Can I file under EB1? So the answer is yes, but before you move, and I just actually did a consultation on this just a half an hour back. Before you move, you should definitely have your lawyers, either the ones you already have or the ones you intend to hire, review the job description in India and make sure they are satisfied that this would work for an EB1. Otherwise, you could be wasting 1 year. Okay. So yeah, that's my only recommendation. Other than that, I think you're okay. So I have a raised hand from California. Not sure what is that about, but let's see. Yeah, California, go ahead, please.
Hi, Rajiv. Thank you. This is Adi. You were just answering my question.
Okay.
Thank you for that. I'll consult with the attorney who is handling my case.
Yeah, I want to make you aware of one thing. There are two kinds of managers: people managers and function managers. People managers must be managing other professional people. So if you are managing software developers, but you're not yourself writing the software or architecting or involved in a substantial way with the actual software, you will be a manager. Cut that to another possibility where you are not actually managing people, but you are in charge of a very important function. For example, pricing. I had a case where somebody was a pricing manager. So their case was denied. We got hired. And we were able to get that approval because that's a very important function and you're in charge of it. So you can be either a people manager or a functional manager. Go ahead with your questions, please, Adi.
Okay, so in my scenario, it is both. I do hands-on work, manage a particular function, as well as manage people who are professionally or technically.
Yeah, you can be both. You can be a combination of both. That's very common.
Okay. So that is a good case.
That's a good thing. Yeah, definitely. That's a good thing. All right.
So the other question I had was, when I work in India, of course, the payroll will run in India. Is there any component of income I can draw in US?
You can get bonuses from USA. But other than bonuses, I think it's better to have your salary paid from the Indian company. Okay.
And in that period, can I travel to US?
Each day you are here, you have to spend an extra day outside USA. And if you are here for too many days, you might have to start your 1 year all over again.
Got it.
Okay.
And if I come, let's say, in between, that means I can come on H1B itself. I don't have to find another visa.
You can also come on an L1A if you want. You can, after 1 year, convert to L1A.
Got it.
Okay.
Does it make any easier to get on EB1, or since H1B is already there, and if I don't travel, I would still have it valid? And I'm ready to come back.
You can go directly to EB1C. You don't have to go on to L1. You can even come on H1B and EB1C can still go on.
Perfect.
All right.
Okay. Thank you so much, Rajiv. We really appreciate it.
You're welcome. Good luck.
Thank you.
Oh no, next is from Venkat. Venkat said, you were my EB2 green card attorney 22 years back. Oh my God, I'm old. Didn't realize that. I just woke up to that fact. Hi Venkat, how are you? So yeah, everything is good here. Still the same crew. All the people that you worked with are pretty much here. Sumanji and everybody is still around. So my sister-in-law, her husband and their daughter and son were admitted to the US on F4 category. Sister-in-law's mother was ill in India. Oh, okay, now I remember. I just read your actually. So the question is, if somebody gives a reason for a re-entry permit to go to India, but that reason vanishes because the person they're going to take care of dies, can we still use that re-entry permit? Absolutely. I don't see, because I think the date you filed the case, that was your reason. You still have reasons to extend your stay, although they are different. But you made no misrepresentations on the date you filed your case. Your situation was absolutely accurately presented. I don't know of any law that affects this, but I don't see why this should be a problem. Venkat, if you are here, press *5. Go ahead. I can hear you, Venkat.
Hello, Attorney Khanna.
How are you, sir? So we are getting old, huh?
Yeah, 23 years back.
Oh my God.
Mine was one of the, I think, the first RIR cases you did.
Oh, wow. That is a long time ago.
So my follow-on question is, when they do end up re-entering, say, next year, could they be subject to the public charge test and all that, or would the affidavit of support be submitted?
I think they can be. I have not reviewed the regulations, as I mentioned, and I'm going to start a page where you guys can post the questions that you have. But I believe they can be. This is my guess. Because if you return after 6 months, your green card is protected, but you're not protected from application of the laws that apply to returning residents. I think, but I could be wrong, and I hope I am. So, but in any case, they're not drawing.
Even according to.
They're not drawing any.
Even according to current law.
Yeah, see, I don't know the answer to that question, frankly. I'm just making a common sense guess. Venkatji, are they drawing any public benefits in USA?
No, they never did. They actually stayed only for 2 months last year before they had to head back to India to take care of their mother.
I would have to.
So they did.
Stand by. I hope you are following me somewhere on the social media, whether it's LinkedIn, Facebook, Twitter. I think we also do Google Plus. Any of the social media that's mentioned, just follow. I'll be posting a link to the new page that I intend to create, where we can start getting all these questions answered.
Okay. But they could be subject to, they would be treated as admission applicants at the port of entry, and they could be subject to.
So I believe it's still an admission, but it's an interesting question. I don't know the answer off the top of my head. Okay.
And the affidavit of support that they received when they initially applied for green cards, would they still hold good? I mean, for the
they are good for for 5 years. Yeah, they should be fine.
But that could not that would not overcome any the fact that they don't have any job in the US and any significant savings here.
I believe that the affidavit of support is just one of the factors. So again, you have me at a loss because I haven't reviewed the regulations. I haven't had the time. Hopefully this weekend I will. Otherwise, I'll get the process started and just do review question by question. So sit tight. We'll be in touch. You have my email. If you don't, just write it down.
Thank you so much.
Yeah, of course, Venkat. Write down my email. It's help@immigration.com.
Sure.
Okay. By the way, my email is still good from 22 years ago. You probably have Khanna@immigration.com. That's still good too.
Okay. Thank you so much.
You're welcome. Good talking to you. Take care.
Glad to.
All right.
Yeah, good talking.
All right. Bye-bye. Wow, 22 years. Okay, Raj, this is the... Oh, what happened here? Everything looks okay. I think we are still recording. Yes, okay. So the last question is from Rajesh 85. My previous H1B expired 2019. Extension was filed before it expired. Case got transferred to Vermont. No updates. Converted to premium. Received an RFE on August 30th. Okay. Now my 240 days is 28 September. It's legally allowed for you to stay. The way I remember the law, and I read this several times, if you file for an extension without change, you have 240-day grace period. But if you apply for a transfer or an amendment or a extension with change, you don't have a 240-day restriction. You can continue working as long as the case is pending. Okay. But if you are subject to the 240-day restriction, you can certainly stay past 240 days. You just can't work. You asked me, specialty occupation, computer programmer, what item should I take care of? That's not a question I can answer, Raj. Our typical RFE response these days is about 600 pages long. So how do I cover something, that kind of information in a phone call? I can't help you. *5 if there's a follow-up question, *5. Okay. Guys, anybody has any new questions? I have about 11 minutes before I have to run. So let's try to answer questions. Press star 5. If you have any question, press star 5. Okay. Oh, that's the first. We have only one question. Very good. Let's do that. Oh, no, there's two. Okay. Let's do two questions. And the first one is from Pennsylvania. Oh, there's three. Okay. Minnesota, Pennsylvania, and what is Emmy? Emmy, it's not Michigan. Wow. Oh, okay. No, this is from California, I guess. No? Yeah, California. Okay. All right. Let's begin with the person who logged in first, which is Minnesota. Let me take Minnesota first. Minnesota, go ahead, please. Minnesota.
Hi, Rajiv. Thank you for taking my call. I have a question kind of from a different scope. I'm actually, I work for a staffing firm, and I am responsible for providing client letters and vendor letters to the companies that we work with who are sponsoring H1B visas. And is that a question you can help with?
Of course. Go ahead.
Okay, thank you. So I'll try and keep this as concise as possible. Our client, from our largest client, our client letter is very vague. So a lot of the information, such as the duration, job duties, and such, are not included in the client letter. So the companies that we work with, the petitioners do ask for a vendor letter that I guess it includes all of those details. But the biggest question that I have been seeing lately is our client releases work orders in only 3 to 6 month durations, regardless of the full duration of the contract that the consultant was hired for, but it's only documented a 3 to 6 month work order end date out there. And I have been receiving a lot of questions in the work order that I would create as the vendor to create a longer end date, even though we don't have that supported by client documentation.
No, don't do that.
Okay.
What you can do.
Okay, thank you.
No, what you can do is you can put a disclaimer in your work order. You can say that we note for the record that our work orders from our prime or from our end client may be of shorter duration. Nevertheless, this is our expected duration. It cannot be guaranteed in contract, equity, or by implied promise. So make some kind of a disclaimer that makes it clear to the government, I'm giving this work order based upon an expectation, not a contract.
Okay, and so then I've always still included that work order end date, and then I do have a disclaimer in terms of the policy, but a lot of companies are now, within the last couple of weeks, asking me to pull that work order end date out there, or like a to be determined end date. Just keep it how we're doing with the disclaimer.
We advise end clients, prime contractors, joint venturers, tie-in arrangements, all kinds of entities who are responsible for giving client letters. My rule is very simple. Never, ever put something down which is not true, strictly true, and never try to conceal any facts. So you can be guilty of misrepresentation by concealment as well as by active inducement. So if you tell a lie or you conceal the truth, you are guilty.
Okay, that is exactly what I needed to hear. Thank you so much.
You're welcome. Good luck.
Yes, thank you.
Okay. Let's go on to Pennsylvania. Okay. Pennsylvania, go ahead, please. We can hear you.
Hello, sir. This is Tarun from Pennsylvania. My question is regarding the work location. So I'm a lead DBA. So I work in a home office, which is mentioned in my petition, 5 days a week. But because of the nature of my work, something goes down off hours, I have to log in and I have to talk to my team and I have to work off hours. I live like 12 miles from my office, but I do work, but then I have to work hours from my home.
Okay.
So does this need a separate change amendment in my application? Do I have to have a second location of work in my amendment?
No.
Or can I work from home?
Okay. No, see, if you're working from home occasionally, what does that mean? There's no rule for that. I can give you some idea of Department of Labor says less than 30 days in any 12-month period is probably occasional. Okay. So if in any 12-month period you are working less than 30 days from home, you are protected. That would be my guess, first thing. Second thing, because they are so close to each other, under matter of CIMEO, which is a decision adopted by the USCIS, it's the same geographical area. Okay. And if you were working from two offices, I will say use the same LCA, just post the LCA in the second location. Here, the second location is your home. Posting LCAs is ridiculous. So I don't think you need to worry about it. You're fine.
Okay.
All right?
Okay. That helps.
All right. Good luck.
Perfect, sir. Thank you. Thank you so much.
You're welcome.
Thank you.
Mm-hmm. Okay, let's go to the last call for today, which is California. California, go ahead, please.
Hello, Rajiv. This is Adi again.
Yes, Adi.
This is regarding traveling to India.
Right.
To come back. And
right. The EB1C case. I have it in front of me. Yes. Question number 15. Go ahead.
So, during that period, can my family, who is on H4 at this time, stay in United States on H4 visa, or they need to be in India with me?
They need to be in India with you. If you leave for such an extended period of time, they are not allowed to stay in the USA on a derivative visa. Okay?
Got it.
Good luck.
Thank you.
You're very welcome.
Good. Thank you again.
You're welcome, sir. Good talking with all of you folks, guys. I will see you again in 2 weeks' time. It's always a pleasure and a delight to be able to provide some guidance on things that I know about. We'll talk again. Thank you very much. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.